What just happened on Capitol Hill could fundamentally reshape how the United States handles immigration from its northern neighbor. And the most stunning part is that it wasn't the Democrats who made it happen. Within the last 72 hours, a significant block of Republican lawmakers broke ranks with the Trump administration on a critical Canada-related measure, and the implications for visa holders, green card applicants, and cross-border workers are far more serious than most people realize. If you hold TN status, if you're in the middle of a green card process with Canadian ties, if you have family members who travel between the U.S. and Canada regularly, or if you're an employer who relies on Canadian talent, what I'm about to break down could directly impact your immigration timeline. This is not speculation. This is policy analysis based on what actually occurred. And by the end of this video, you'll understand exactly what happened, who's affected, and what steps you need to consider taking right now. My name is Alexander Pierce. I'm a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't do rumors. I don't do clickbait panic. What I do is track policy shifts, legislative actions, court decisions, and regulatory changes, and translate them into practical information for people whose lives depend on understanding the U.S. immigration system. Now, before we go any further, the standard professional disclaimer. I am not your attorney, and this content is for educational and informational purposes only. Immigration law is highly individualized. What applies broadly may not apply to your specific situation. Always, and I mean always, consult with a licensed immigration attorney about your particular case before making any decisions. With that said, let's get into exactly what just happened with this shocking Republican vote on Canada immigration policy. The Trump administration had been pushing forward with a policy framework that would have significantly tightened scrutiny on certain visa categories commonly used by Canadian nationals. Specifically, they were targeting the TN visa program under USMCA, as well as proposing enhanced vetting requirements for L1 intra-company transferees and certain employment-based green card applicants with ties to Canadian companies. The rationale from the administration was national security and labor market protection. The argument was that cross-border movement, even from allied nations like Canada, required stricter oversight in the current environment. They pointed to concerns about economic competition, job displacement for American workers, and what they characterized as insufficient screening mechanisms at the northern border. This was not a small policy tweak. This was a fundamental reorientation of how the United States approaches immigration from its closest ally and largest trading partner. But here's where things took an unexpected turn that stunned political observers on both sides of the aisle. A coalition of Republican lawmakers, many from border states and states with significant economic ties to Canada, broke with the administration and voted alongside Democrats to pass an amendment that would block funding for implementation of these enhanced restrictions for the remainder of the fiscal year. The vote was closer than many anticipated, but it passed, and the message it sent was unmistakable. Even within the president's own party, there is significant resistance to policies that could disrupt the economic relationship with Canada and affect hundreds of thousands of workers operating under existing visa frameworks. We're talking about Republicans from Michigan, Ohio, Montana, North Dakota, Washington State, and other regions where Canadian trade and cross-border commerce represent billions of dollars in economic activity. These lawmakers heard from businesses, from hospitals, from tech companies, from agricultural operations, all saying the same thing. Restricting Canadian immigration would cause immediate and severe economic harm to their constituents. But here's where this becomes critical for anyone watching this video. This vote does not end the policy debate. It creates a temporary funding block, not a permanent statutory change. And understanding that distinction is essential if you're trying to figure out how this affects your case. Let me break down the procedural mechanics so you understand exactly what kind of decision this was and what it means for the future of U.S. Canada immigration policy. This was a congressional appropriations amendment. It passed in one chamber, the House of Representatives. It has not yet been taken up by the Senate, and it has not been signed by the President. Under the U.S. legislative process established by the Constitution, for this funding block to become binding law, it would need to pass both chambers and either receive presidential signature or achieve a veto-proof majority if the president rejects it. Now, the administration has authority under existing immigration law, specifically under the Immigration and Nationality Act, or INA, to implement policy through regulatory channels and executive action. The Department of Homeland Security, through USCIS and CBP, has significant discretion in how it adjudicates visa applications and enforces entry requirements at ports of entry. What Congress did here was attempt to use the power of the purse, its constitutional authority over federal spending, to restrict the executive branch's ability to fund and implement these specific policy changes. This is a classic separation of powers dynamic playing out in real time, with immigration policy caught in the middle. This is what many people are misunderstanding about this vote. The vote itself is significant politically. It shows fractures within the Republican coalition on immigration policy toward Canada. It demonstrates that the Trump administration cannot assume automatic support from its own party on every immigration initiative. It signals to the business community that there are lawmakers willing to push back on policies they see as economically damaging. But legally, the policy restrictions the administration proposed are not yet dead. They're in limbo. If the Senate does not take up this amendment, or if a compromise is reached that removes this provision, the administration could still move forward with implementation through executive channels. And that uncertainty is exactly why anyone potentially affected needs to be paying close attention right now to U.S. Canada immigration news. Let's talk specifically about who should be watching this development most closely and what visa categories are potentially impacted. First, TN visa holders need to understand what's at stake. The TN visa, created under NAFTA and continued under USMCA, allows Canadian and Mexican citizens in designated professional occupations to work in the United States. It's one of the most streamlined visa categories available in the entire U.S. immigration system. Canadian citizens can often obtain TN status directly at the port of entry without pre-filing a petition with USCIS. You show up at the border with your qualifying credentials, your job offer letter, and supporting documentation, and a CBP officer can grant you TN status on the spot. It's been this way for decades, and it's facilitated the movement of hundreds of thousands of professionals between the two countries. The proposed restrictions would have introduced additional documentation requirements and potentially mandatory pre-approval through USCIS before Canadian nationals could obtain TN status at the border. That would have fundamentally changed how the TN process works and added months to what is currently sometimes a same-day process. Imagine going from same-day approval at the border to waiting 4, 5, 6 months for USCIS processing. For many job offers, that delay would be a deal-breaker. Employers would look elsewhere. Opportunities would be lost. The entire advantage of the TN category would be eliminated. If you're currently on TN status or planning to apply for TN status in the coming months, this policy fight directly concerns you. Second, L1 intracompany transferees should be monitoring this situation closely. The L1 visa allows companies to transfer executives, managers, and employees with specialized knowledge from foreign offices to U.S. offices. Many Canadian companies use this pathway to move key personnel into American operations. Tech companies, manufacturing firms, financial services companies, healthcare organizations all rely on the L1 category to staff their U.S. operations with experienced personnel from their Canadian headquarters or affiliates. Enhanced vetting requirements could mean longer processing times, more requests for evidence from USCIS, and potentially higher denial rates. We've already seen denial rates for L1 petitions increase in recent years. Additional scrutiny requirements could accelerate that trend. Third, employment-based green card applicants need to understand the potential implications. If you're in the EB2 or EB3 categories and your sponsoring employer has Canadian ownership or significant Canadian operations, you could face additional scrutiny under national security review provisions that were part of the proposed framework. This could affect your I-140 immigrant petition processing. It could affect your I-485 adjustment of status application. It could introduce delays at the National Visa Center or during consular processing if you're going through that route. There's one detail most people are missing about this situation. Even if you're not in one of these specific visa categories, increased scrutiny at northern border ports of entry could affect routine travel, re-entry after trips abroad, and processing times across multiple visa categories as resources are reallocated. When CBP officers are directed to conduct enhanced screening at the Canadian border, that takes time and personnel. Those resources have to come from somewhere. Processing slows down across the board. Wait times increase. Secondary inspection referrals become more common. This isn't just about TN holders. It's about the broader framework of U.S. Canada immigration relations and how policy changes in one area create ripple effects throughout the entire system. Let me give you a realistic example of what this looks like in practice for real families navigating this uncertainty. Consider a software engineer. Let's call him David. David is a Canadian citizen who has been working in Seattle on TN status for 5 years. His wife, also Canadian, is on TD dependent status. They have 2 children who were born in the United States and are American citizens. David works for a major tech company. He's well regarded, well compensated, and deeply integrated into his team. His employer recently began the green card sponsorship process because they want to retain him long term. His I-140 immigrant petition was approved 8 months ago, and he's now waiting for his priority date to become current so he can file his I-485 adjustment of status application. Here's David's concern. If the proposed restrictions had gone into effect, his next TN renewal, which he needs to maintain status while waiting for his green card, could have been subject to enhanced vetting. Any delay or denial would put his entire family's situation at risk. His wife's dependent status is tied to his TN. If he loses status, she loses status. His children, though U.S. citizens by birth, depend on their parents being legally present to maintain the family unit. And his green card process, years in the making with thousands of dollars invested in legal fees, would be jeopardized if he fell out of status before filing his I-485. This is not hypothetical anxiety. This is the lived reality for thousands of families whose lives are built on the stability of cross-border immigration pathways. David has been checking the news every day. He's been in contact with his immigration attorney. He's been documenting everything, preparing for multiple scenarios, trying to stay ahead of policy changes that could upend his entire life. This could affect you even if you're not in David's exact situation. The point is that immigration status is interconnected. A policy change that seems narrow on its face can ripple outward and affect family unity, employment stability, and long-term plans in ways that aren't immediately obvious. Now, let me give you a structured action plan. Whether you're directly affected by this U.S. Canada immigration policy fight or simply want to be prepared for whatever comes next, these are the steps I recommend taking right now. First, gather and organize your documentation. If you hold TN status, L1 status, or you're in an employment-based green card process, make sure your documentation is current, complete, and organized. This includes approval notices, I-94 records, employment verification letters, pay stubs, tax returns, and any correspondence from USCIS. Create both physical and digital copies. Store them securely. Know where everything is so that if you need to respond quickly to a policy change or a request for evidence, you're not scrambling to find documents. If enhanced vetting requirements are eventually implemented, having a well-documented file will be essential. Officers and adjudicators look more favorably on applications that are thoroughly documented and professionally presented. Second, monitor USCIS and CBP updates directly. Do not rely solely on news headlines or social media posts. There is so much misinformation circulating about immigration policy, and acting on bad information can have serious consequences for your case. Go directly to uscis.gov, cbp.gov, and the Federal Register for official announcements. Policy changes are published through formal channels before they take effect, and knowing the actual effective dates matters. Sign up for email updates from USCIS. Check the CBP website regularly if you travel across the border. Read the actual text of announcements, not just headlines about them. Third, avoid status violations at all costs. This is always important, but it's especially critical during periods of policy uncertainty. Do not overstay your authorized period of admission by even a single day. Do not work without proper authorization. Do not engage in activities inconsistent with your visa status. Do not assume that pending policy changes mean current rules aren't being enforced. They absolutely are. If anything, periods of policy transition often see increased enforcement as agencies demonstrate their commitment to immigration control. Any status violation, even a technical one, can be used against you in future applications. Protect your record. Follow the rules. Don't give anyone a reason to question your eligibility. Fourth, be cautious of immigration scams. Whenever there's policy uncertainty, scammers emerge. They prey on fear and confusion. They promise special access, guaranteed approvals, or claim they can help you get around new restrictions. Be wary of anyone who guarantees outcomes that seem too good to be true. Be suspicious of people claiming to have insider connections at USCIS or DHS. Never pay for services without verifying credentials. Work only with licensed attorneys or DOJ-accredited representatives. Check credentials through your state bar association or the DOJ website. Get referrals from trusted sources. Protect yourself from exploitation. Fifth, consult qualified legal professionals. If you have specific concerns about how these developments might affect your case, schedule a consultation with a licensed immigration attorney. An attorney can review your individual circumstances, assess your risk exposure, and provide tailored advice based on the latest policy developments. Yes, consultations cost money, but immigration mistakes can cost far more in the long run. The peace of mind that comes from professional guidance is worth the investment, especially during uncertain times. However, this protection may not be permanent. Remember, the House vote created a temporary funding block, not a lasting statutory prohibition. The policy landscape could shift again, depending on what happens in the Senate and whether the administration pursues alternative implementation pathways. The relief that TN holders and others may be feeling right now is provisional. It's based on a single legislative action that has not yet been finalized. Continued vigilance is essential. Let me put this in broader context so you understand what happens next in this fight over U.S. Canada immigration policy. As of now, we have an amendment that passed the House of Representatives with bipartisan support, including a notable number of Republicans who broke with the Trump administration. For this to become law, several things need to happen. First, the Senate must take up the measure. This could happen through a standalone vote, though that's unlikely given competing legislative priorities. More probably, it would be folded into a larger appropriations package or continuing resolution. Senate leadership has not yet indicated their timeline, and the Senate has its own political dynamics that may or may not align with the House vote. Second, if the Senate passes a different version, and they often do, the two chambers would need to reconcile their bills through a conference committee. This is a negotiation process where House and Senate representatives work out a compromise version that both chambers can accept. Immigration provisions are often traded away during these negotiations in exchange for other priorities. Third, the final bill would require presidential signature. Given that this amendment directly contradicts the administration's stated policy goals on northern border security and Canadian immigration, a veto is not just possible, but probable. The president has made clear that immigration restriction is a priority, and signing a bill that blocks his own policy would be an unusual concession. Overriding a presidential veto requires a two-thirds majority in both chambers. That's a very high bar. While the House vote showed bipartisan support, it did not reach veto-proof levels. The math in the Senate is even more challenging. Fourth, even if the funding block becomes law, the administration could pursue alternative implementation through executive action that doesn't require the blocked funding. They might use existing personnel and resources. They might phase in changes gradually. They might find regulatory workarounds. Alternatively, they could simply wait until the next fiscal year and seek new appropriations with different provisions. Funding blocks are temporary by nature. They expire when the appropriations period ends. Realistically, we are looking at a window of continued uncertainty. Based on the legislative calendar, potential court challenges, and the administration's options, I would estimate that clarity on the final disposition of these proposed restrictions will not come for at least 60 to 90 days, possibly longer. And during that period, the situation could change multiple times. New votes could occur. New executive actions could be announced. Court cases could be filed. The landscape is dynamic. This is what many green card applicants and visa holders are misunderstanding about how immigration policy actually works. A single vote, even a dramatic one that makes headlines and shocks political observers, is rarely the end of the story. Immigration policy is shaped through a constant interplay between Congress, the executive branch, and the courts. Each branch has its own powers and limitations. Each can check the others, but none can act unilaterally without response. Staying informed means tracking all three branches. It means understanding how a House vote relates to Senate action, relates to presidential response, relates to potential judicial review. It's complex, but that complexity is exactly why you need reliable sources breaking down these developments in clear, factual terms. Before I close, I want to reinforce why this matters beyond the immediate policy details and political drama. Immigration status is not an abstract legal concept. It is the foundation on which people build their lives. It affects family unity, whether parents can remain with their children, whether spouses can stay together, whether siblings can reunite, whether families can plan for a future in the United States without constant fear of separation. It affects employment stability, whether skilled professionals can continue contributing to American companies, whether businesses can retain the talent they've invested in training and developing, whether innovation continues flowing from the people who drive it, regardless of where they were born. It affects financial security. Mortgages depend on stable employment. Retirement savings depend on continued income. Healthcare coverage depends on employment relationships. Education plans depend on the ability to remain in the country long enough to complete them. And it affects long-term residency and citizenship plans. The pathway to permanent belonging in this country, the ability to vote, to fully participate in civic life, to feel secure that this is truly home. When policy shifts create uncertainty, real people feel real consequences. Families lose sleep, workers worry about their futures, children sense their parents' anxiety without fully understanding why. That's why I take this work seriously. That's why I focus on facts and analysis rather than sensationalism. That's why I believe staying informed is not just helpful, but essential for anyone navigating the U.S. immigration system. The situation with Canada immigration policy is still developing. The Republican break with the Trump administration was significant, but it's not the final word. More developments will come, more votes will occur, more decisions will be made. And when they happen, I'll be here to break them down for you in clear, practical terms you can actually use. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video helped you understand what's happening with U.S. Canada immigration policy and the Trump administration's conflict with its own party, hit the like button. It helps this content reach more people in the immigration community who need accurate information rather than rumors and speculation. Drop a comment below with your visa category. Whether you're on TN status, L1, H1B, in a green card process, or any other category, let me know how these developments might be affecting you. I read every comment, and your questions often shape future content on this channel. And if you know someone, a colleague, a family member, a friend, who might be affected by what I covered today, share this video with them. Getting factual information into the right hands can make a real difference in how people navigate uncertainty and protect their immigration status. Thank you for watching. Stay informed, stay prepared, and I'll see you in the next one.